Mr. Mayor, if you're ready, why don't you come up and have a seat? Gentlemen, if you'd have a seat over on plaintiff's side.
Thank you, Your Honor. Why is someone here? Your Honor.
Yes.
Do you plan on live streaming?
Yes, I do.
Is it okay if I set up a camera or is that inappropriate?
It's not allowed under the court rules. Whatever you want to have preserved will be on there. It's unlawful to have extraneous recordings in the courtroom. In fact, even the police can't wear their body cams in here.
Thank you, Your Honor.
All right. I don't have a philosophical objection to it, but yeah, they wanted to, anyway, it's all preserved both on the formal record and for a few days it will be on YouTube.
Thank you.
I think we got everybody we need. Good evening. He's no longer representing Mr. Mayor. He's pro per. Well, settle that. All right, so let's get started. All right, let's go on the record. All right, we're here this afternoon on a couple of matters. What is originally set for was the defendant's motion for stay of enforcement pending final order, pending appeal. The file number is 2420690N and 25188ON. Title of the case is Lockport Township versus Anthony Mayer. Mr. Mayer filed this motion in November on the 4th, and frankly, I'm embarrassed that it took us this long to get it set. But we had some adjournments that were requested, objected to, and ultimately we settled on this date. This is my first day back from a vacation. Somehow I thought this would be a good idea to do it on that day. Seemed like a better idea then than it does now. I looked at it before I left, and then some additional pleadings came in while I was gone, which I've had an opportunity to review today. Mr. Mayer is here representing himself. Mr. Mayer, at the hearing we had, you were represented at one point by Attorney Burt and then at one point by Attorney Truckee. At this point, Mr. Truckee is no longer representing you, and you're here in your own behalf, representing yourself.
Yes, Your Honor.
All right, that is your absolute right. You do better at this than some, but frankly, I was pleased when you had a lawyer to help you, but you have a right to represent yourself. Here on behalf of the township, again, from Fahey, Schultz, and Birch, and Rhodes, we've got Mr. Trent Cunningham, and we've also got David Szymanski, correct?
Correct.
All right. I called him by your name, and I called you by his name, so I might do it again before we're done, but I'll try not to. All right. So let's go back to where we are. The court made a ruling in their order, which was dated the 14th of July, 2025, order requiring compliance with the ordinance. It's included in the filings. It's also included in defendant's brief as exhibit number 13. In that, I ordered that the defendant remove the property, personal property, trucks, trailers, tail lifts, anything from the property in Lockport Township. It was to be done, I believe, within 21 days. That order was filed under the 7-day rule. No objection was entered, and the order was signed on, as I stated, June 25th. So my intention was the defendant would have a certain period of time to remove the property from that lot. He attempted an appeal in circuit court. It was rejected. Then he reappealed it. And I believe there's an appeal pending in circuit court. He is at this point asking me to stay my order. The township objects. So, Mr. Mayor, I'll allow you to argue first. Then we've got this other thing that was filed while I was gone. Notice of jurisdictional issue raised and preserved. We'll set that aside for the time being. And now we'll just deal with the issue regarding the stay. Mr. Mayor, as I said, you do better than some people representing yourself. I think you've become pretty proficient in ChatGPT or other assists. What would you like me to know?
Thank you, Your Honor. Your Honor, I'm requesting a stay solely to preserve the status quo while circuit court appeal, now fully briefed, is under advisement. I'm not asking the court to rule on merits. This court has discretion to issue a stay to prevent enforcement that would cause irreparable consequences while appellate review is pending. All appellate briefs were submitted on December 30th, 2025. The appellate record is closed and the circuit court's decision is now pending. Because the appeal is already under advisement, enforcement actions taken now would not advance resolution. They would only risk prejudice before appellate review is complete. If enforcement proceeds now through removal of property, penalties, or compelled compliance, those actions cannot be undone, even if the appeal succeeds. That would effectively decide the case before the appellate court rules. I have acted in good faith throughout these proceedings. I have complied with directives, removed items identified by the township, and posted the bond accepted by the circuit court. I am not refusing compliance. I am requesting a pause while the appellate court deliberates. For the record, I note that I have preserved jurisdictional and procedural objections previously raised. I am not seeking ruling on those issues today. I respectfully ask the court to preserve the status quo until the circuit court issues its decision. Thank you, Your Honor.
All right, those are logical, well presented arguments. Essentially saying, I wish to have the circuit court make their ruling before you make this ruling, which is short and to the point. So I appreciate that. Township, however, has another view of this. Who's going to argue this?
I will, Your Honor.
All right, go ahead.
Thank you, Your Honor. So we would ask that the court deny Mr. Mayor's motion for a stay for two main reasons. One is that Mr. Mayor can't show a likelihood of success on the merits on appeal, but more importantly, the balance of equities here just do not cut in favor of granting a stay. They would in fact cut in favor of compliance with the order and with upholding the township's ordinances. Secondly, Mr. Mayor has not alleged a sufficient basis that would support granting a stay. As for the law on this matter, under Michigan law, there's no explicit test for granting an order or for granting a stay of an order pending appeal in these circumstances. Courts have explained that it would be appropriate to look to the likelihood of success on the merits as well as the equities involved. Understanding that an inquiry into the merits of this case would be asking this court to essentially find that it made reversible error. We don't think it's necessary to get into the merits at this point. And as Mr. Mayor indicates, he's not trying to argue the merits. However, we're happy to go down that road if the court would want to. I think what's more important is that the balance of the equities here favors denying the stay. Compliance with the order at this point requires minimal burden by Mr. Mayor. This case does not involve tearing down property. It doesn't involve enforcing the order would not involve taking actions that can't be undone. It simply involves moving property or moving the equipment and the vehicles that are subject to the order from the property. And that's all it would take. If Mr. Mayor were to succeed on appeal, the equipment could be moved back. There's no irreparable harm at issue in this case. On the other, and this court correctly observed that, and as reflected in the transcript when the court said, quote, "This is relatively easy. You're an auction guy, you've got trucks, you've got trailers, you've got a place to put it. Take it there and put it there." Mr. Mayor even indicated on the record, which is also reflected in the transcript, that he has alternative property to put this equipment on. And so there would be no irreparable harm or even burden to simply move the prohibited equipment during the time of this appeal pending. And like I said, if he were to succeed, it could be moved back. There's no irreparable harm. On the other hand, township residents face substantial and irreparable harm. There's unrebutted expert testimony from Mrs. Nowicki, who's a realtor with 31 years of experience, but this court qualified as an expert, that the conditions on Mr. Mayor's property could cause a drop in real estate prices in the area, as well as making prospective buyers less likely to buy. That is an irreparable harm that could be caused by noncompliance with this order. Simply moving equipment is not the same. The minimal inconvenience of relocating construction equipment, a task that is well within Mr. Mayor's professional capabilities, can't justify prolonging these violations, which could decrease property values and harm the community. As for our second point, Mr. Mayor claims in support of his appeal, he alleges all these conclusory statements about the merits of the case. And those conclusory statements are not sufficient to support granting a stay in this instance. One of those claims is that the order exceeds the text of the ordinance by regulating property that's never defined by the code. As this court properly observed and directed the township to submit the order under the 7-day rule, we did that, and the court even explained to Mr. Mayor the process of that 7-day rule and how the order could be objected to, and the court would hold a hearing on that. We submitted the order along with this court's direction, and there was never an objection submitted by Mr. Mayor, and so the order was entered. This court should not grant a stay simply now because Mr. Mayor has taken issue with the terms of the order when there was no timely objection filed, and those issues are now waived. As well as Mr. Mayor claims that there's zoning style restrictions in the police power ordinance. Again, I think this cuts towards the merits of the case, which I don't think this court necessarily needs to get into at this point, but we're happy to get into that if necessary. However, he provides no legal authority or support or examples as to those zoning style restrictions, and there's just no evidence or legal support for those claims. And third, Mr. Mayor alleges in his brief that the stay should be granted due to substantial compliance. It's unclear to the township how substantial compliance would justify granting a stay in this case. If substantial compliance has not caused irreparable harm, and as Mr. Mayor indicates through his argument to the court today, he has removed much of the equipment that would be subject to the order. If that doesn't cause irreparable harm, then it's unclear how full compliance with the order while the appeal is pending would cause irreparable harm. And so I would just underscore that this is not an issue like tearing down a building or taking some sort of enforcement action that can't be undone. It's simply moving vehicles. The township and its residents have had to put up with these violations for a long time now. Mr. Mayor's briefs even indicate that some of the equipment that's subject to the order, such as some trailers and some scissor lifts, are still on the property. And so we don't even have full compliance with the order, even though the order has been in place for over 6 months now. And so I think that the balance of the equities in this case and the lack of irreparable harm would justify this court denying the request for a stay and maintaining the status quo by just keeping this court's order in full force and effect during the period of the appeal, which is where the circuit court ultimately came down on the issue as well when they denied the appeal. So we would ask that the court denied the request for a stay. Thank you, Your Honor.
I do have a question. His contention, Mr. Mayor's contention, is that the matter's been argued in circuit court and is pending an appeal. Pending an opinion. I didn't understand that was the case.
Your Honor, the issues have been briefed in circuit court. There has been no oral argument in circuit court. And at this point, I am not sure if the court will choose to set it for oral argument or if the court will just decide it on the briefs.
Has there been any date set?
Not as far as we're aware, Your Honor, we have not received notice of a date, and I did check the court docket this morning, and I didn't see that anything has been set yet.
It takes a long time to do things in circuit court. I have a case that's caused me some consternation for several years. It got bound over to circuit court, or removed to circuit court as a civil case. And I just saw it been set for trial in June. It's already about 3 or 4 years old. And both parties are suffering from the delay in the case. That's just part of the legal process. Mr. Mayor, you're always polite, respectful, and your pleadings are actually in the ballpark. Your argument today was spot on. You're not asking me to reconsider the matter. You're simply asking me to pause it while circuit court makes their ruling. When I make my ruling and I issued the order, that's Exhibit 13, that's my finding. I had a rigorous trial. I heard testimony from people. I looked carefully at the statute, police powers versus zoning enforcement. I looked at the ordinances. I looked at lots of pictures. I'm familiar with the property. I drive past it fairly often. And I made a ruling that said, this is what I want you to do. Within 21 days. And then you filed an appeal, which is your right. But I don't wish to stay it. I made my ruling and that's what I wanted you to do. If the circuit court wishes to stay it, they can so decide. This would just invite everybody to appeal every zoning enforcement order if all they have to do is file an appeal and then I stay it in district court. It's going to take a year to get this case resolved in circuit court. Transcripts have, I don't know if they've been prepared. They have to be prepared. Briefs have been filed. It hasn't been scheduled for anything. I don't know where it's headed. And my analysis of this was very close to Mr. Cunningham's analysis of it. There is no irreparable harm. He mentioned tearing down buildings. I have ordered in my tenure that stuff be torn down, important stuff. Somebody's house, part of their house and garage that was built into the actual road right of way in another township. I ordered the church be torn down in Park Township. There's not much appeal from that. If I don't stay it, it's torn down. It's like asking for a stay of execution and you don't grant it and the person gets executed and then they find there was appeal merit and the matter was reversed. Well, that's irreparable harm in its purest sense. Here, there is no irreparable harm. You've already claimed substantial compliance, that you've moved some stuff, move the rest of it. You have a place to put it. You have the wherewithal to move it. If Judge Stutzman rules in your favor, you can return the property back there, or pursue the building of that pole barn or whatever you're going to put on that excavated portion of it. So no, I meant what I said. I don't think there's a likelihood of prevailing on appeal, which would essentially state, I think I was wrong and the circuit judge is going to reverse me. I think I was right. I think I followed the law. I think my ruling was based on the facts. I don't have to like it. Zoning enforcement is not my favorite topic, but it's part of my obligations. So I do not find that there is a likelihood.
May I speak real quick?
Let me finish. Well, all right, go ahead.
I don't mean to interrupt you.
But you just did. So go ahead.
First off, Your Honor,
I did follow your direction at trial, and I requested a stay in front of Stutzman. He sent it back to you. That was his direction, not mine. I've been requesting a stay since July
Yes.
of last year. Also, irreparable harm will occur because I will lose my constitutional rights for the time that enforcement is forced. Forced removal of property cannot be undone on appeal. And compliance moots the appeal. Irreparable harm does exist. Thank you, Your Honor.
Thank you. And you made a point. Yeah, Judge Stutzman kicked it back to me. He chose not to do it. He remanded it back to me to rule on the stay, and my ruling is I'm not granting one. You can ask him for one. I meant what I said the first time. If the circuit court wishes to stay it, I believe they also have the authority to do it. You made that point and I didn't, so thank you. And we have a different view of irreparable harm. There may be harm, but I don't know it's irreparable. So I find there is not a likelihood of prevailing on the appeal. I believe my ruling was correct. Secondly, I do not find that there's irreparable harm to the defendant in moving this property off this lot. We're in the middle of an Arctic blast. Nobody's going to do anything right now. I'm going to grant the defendant 21 days to remove the property from that address, or the township can take the enforcement action that was in the original order. So my original order of June 25th, you did get a stay. You got a stay from June 25th till 21 days from today. The order of June 25th is in full force and effect and within 21 days. Now, you do have the right, and you feel very strongly about this, and you've done a creditable job in defending yourself. You can ask Judge Stutzman to look at it again, and maybe I'm mistaken. Maybe this is going to be decided in the circuit court soon. There's a lot of stuff going on. There are a lot of serious felony cases pending. Several murder cases, several assault with intent to murder cases, several large criminal sexual conduct charges. The circuit court is going to be moving to Three Rivers. There's going to be a lot of other court cases requiring the time of the circuit court. And so I don't think this is quickly pending a decision.
Your Honor.
Yes.
There's some things I need to request that you put on the record.
All right, well, we'll get to that in a minute.
The other thing I was going to ask is that you make a determination. I think one of the things that the township is threatening with, they want me to remove that lift that I utilize on the property on a regular basis for maintenance.
It's going.
Talked about that.
You can bring it back and forth. My order says what it says. All that stuff is in there. I'm not going to nickel and dime it. You can move it off of there. If you need to bring it back to your house for maintenance, you can do that.
Can you clarify on personal use trailers?
You can't park anything on that lot.
Even personal
everything.
vehicles, personal trailers, personal vehicles, personal equipment. Or I'm not talking construction equipment. I mean, everything that I use to move my dirt bikes, my four-wheelers, my side-by-side, my lawnmower.
I'm not gonna nitpick this, because what you're gonna do is you're gonna then put a bunch of other trailers on there, and then we're gonna have to figure out how many angels can dance on the head of a pin.
Your Honor, I have a large piece of property because I have a lot of things.
Yes,
I have a large house. This is why I have property.
yes.
And I have no plans to build a pole barn, just so you're aware.
Well, I thought we discussed that. You had excavated that portion there, and I thought at some point you were gonna put up a.
I think Doug Coleman's in your ear. I think.
No, I thought you told me that. I've actually looked at it. There's a big excavated portion that looks like it was cleared out for pouring a slab.
What I was doing is there's topsoil on that end of the property for some reason. For some reason, that end of the property, once I took elevations, that end of the property is 30 inches higher than the other. So after I finished backfilling around my house, which I was interrupted at the exact, roughly a year ago. And I've communicated all this with Doug Coleman a year and a half ago now. But my point is that I had no plans. I talked with him about in the future possibly building a pole barn, but I'm still trying to fix the drainage issues.
All
And
right.
I don't have any equipment to do that
All
with
right,
now.
maybe that's where I got it. But anyway, at any rate, it's not imminent that there's gonna be a storage building put on there. So that's not a
Well, I
solution.
can't do that without tools, and then my tools have been taken away from me.
All right. Okay, so I would ask the township to present an order saying that I denied the motion for stay. I don't find a likelihood of prevailing on appeal, and I don't find any irreparable harm. 21 days from today, the township can seek the enforcement that was in the original order of, I think I actually signed it on July 14th. All right. Mr. Mayor wants to preserve some other things for the record, and you filed an additional set of documents. I left on the 10th. I guess this was filed on the 9th. I didn't see it until this morning, but it's entitled Notice of Jurisdictional Issue Raised and Preserved. And then it's defendant's motion to supplement and correct the record. Submits the following for inclusion. This filing is submitted solely for record preservation purposes. It does not seek a ruling, does not request relief, does not ask the court to take any action. The appeal in this matter is presently pending before the circuit court. So these are things you wish to be preserved as part of this record so the circuit court can consider them. And it is a file document. So what else do you want me to know, Mr. Mayor?
Well, I just was hoping that you could make a determination, make a finding on the balance of harms and the public interest, those two things. I did hear your finding on.
Here today?
Well, I heard your finding on likelihood of success on appeal, and I heard your finding on irreparable harm asked in a stay. I apologize. I'm doing my best. I'm a carpenter.
You're doing fine. I just disagree with you. That doesn't mean that you're deficient. Let's say you had a lawyer and Mr. Burt were here, or Mr. Truckee were here, or other counsel. I would disagree with them too, and I'd issue the same ruling. So you're doing fine. I'm not critical of your self-representation at all. I just have a different view of things than you do. Now, these issues you want to have raised and preserved here, I guess they're raised and preserved by filing these documents. So I don't know what else to say about it. Is there anything you wish to further address regarding those things you filed on January 9?
I don't believe that anything needs to be said, Your Honor. Thank you for the opportunity.
All right, Mr. Cunningham?
Your Honor, I guess we don't have a whole lot to say on it as well, especially if the court's not going to make a ruling. I think as far as preserving things in the record now, I think the record on appeal is closed. That wasn't raised at the formal hearing. And so I don't know if there's any basis to submit things into the record now at this stage.
I guess he can ask to do it in circuit court. It sort of reopens the case, but he said the trial record is what it is. Everything that was said here is preserved verbatim on the record. And I believe Judge Stutzman, I don't know if is the transcript been prepared of that yet?
Yep, we have a
Alright,
transcript, and that's, I think to my point is that we have the transcript, we have all the exhibits that were admitted at the trial, and as far as preserving these issues, they weren't raised below, they weren't decided by this court, and I don't know that.
And so he's got them preserved in his pleadings, and if he wants to address it further in the circuit court case, he certainly can take it up with Judge Stutzman. Again, I've made my ruling. We have 21 days. Judge Stutzman elected not to grant a stay. He didn't deny it. He remanded it back to me, and I have denied it. So I guess you can ask him within 21 days. But I've made my ruling. Or is there anything else we need to place on the record?
We have nothing else, Your Honor.
All right, this matter is completed. I'll wait your order. Again, it will be under the 7-day rule, as I explained to you the last time. And I will sign it if there's no objection to it, but it's pretty straightforward. The original order stands. You have 21 days to come into compliance, or they can seek enforcement.